and has also written a commentary on the Information and Technology Act. He was also visiting faculty in NLU Delhi and NLS Bangalore. He is featured in Forbes 30 under 30 lists and was part of some landmark judgments of the Supreme Court, like KS Puttaswamy versus Union of India, Anuradha Bhasin versus Union of India, PUCL, and like etc. Many more. I would like to thank Mr. Gupta to have agreed to be the speaker despite his schedule. And yeah, before we start, I would just like to mention that the format of the webinar would be like Mr. Gupta will be presenting his views for the first 45 minutes. And the last 15 minutes will be reserved for the question and answers. We request the attendees not to unmute themselves during the session and just ask their questions via Zoom chat and direct their questions to Harshit Goel. In the last 15 minutes, we'll call out the names of the people with the questions and then they can unmute themselves. The attendees would be given the participation certificate after the submission of the feedback form, the link of which will be provided at the end of the session. So now, without wasting any time, sir, over to you.
Thank you so much, Karthik, for that generous introduction. I'm a bit dismayed that attendance to this webinar is conditional on a participation certificate. And I mean this in jest because on a Saturday, I do not expect people to do anything beyond what truly excites them. So even if there are 20 people here who want to hear, rather than the 80, it would be much more meaningful. And that's a suggestion I would make on the behalf of the attendees here, even if they can't voice it. Now, beyond certificates by itself, let me tell you a little bit about myself, which is not captured in this introduction. I come from the lawful state of Uttar Pradesh, at least my family does. And one of the old traditions in Uttar Pradesh, which is to my dismay, genuine dismay, has been the incredible amount of patriarchy which has been there for a long period of time, ever since it was called the United Provinces. This was studied to some extent by the feminist scholar Ratna Kapoor in her book Erotic Justice, when she looks at how there are boundaries within what is publicly acceptable and privately acceptable. And she essentially uses this framework to explain through a feminist post-colonial lens and her scholarship that how this dividing line also means what is legal and what is illegal. And this quite often visits itself in commentary around pornography, around obscenity, around social taboo, in a sense, and which is what is one of the most visible categories of what is contentious online. So as much as we speak about China, I would first like to speak about using the examples of dowry calculator and Savita Bhabi, that what is the nature of the website blocking power and how it was used in the context of the app ban in China. Through these three contemporary examples, firstly of Savita Bhavi, secondly of dowry calculator, and third of the much more recent ban or series of bans on smartphone applications which purportedly emerge in China, I would like to give you a full breadth of the law and introduction to it on what constitutes website blocking, why is it troubling, and why it is also undermining our rule of law system, towards posing questions as to whether we are having too much China envy, leaving us to whether there is too much democracy. So firstly, Ratna Kapoor's work, if you look at it, also has commentary on Uttar Pradesh and how the Didi Devar joke or the Bhabi Bhaiya joke is something which is very well accepted inside the household, but not permitted outside it, which is also a form of diffusing sexuality. And one of the most visible forms of how sexuality and social taboo has been negotiated online, especially through the point of creation of Indian erotic figures, has nowhere been more visible in a much more popular setting, at least in terms of academic study, than the figure of Savita Bhabi. And Savita Bhabi was an online web comic, or is still an online web comic, which poses a married woman in certain states of display of sexuality, or whether they do have, and it's led to an incredible amount of scholarship if you look at it a little more deeply. However, the power to block this website, Savita Bhabhi, did come under contention fairly early on. And it will surprise you to know that our present blocking powers under Section 69A of the Information Technology Act, which I will read later, does not even limit it. This was pointed out first by Manoj Mehta on in the Times of India on Feb 11th, 2010, on the front page, when he stated, in a little noticed fallout of the recent amendment to the Information Technology Act 2000, the government has given up the power to block pornographic websites purely on grounds of obscenity. Sites like Savita Bhabhi, in other words, can no longer be banished from the virtual world merely because they don't conform to a Babu's subjective moral view. Now, the courts alone can block such websites. This is because Section 69A, which came into effect on October 2009, has raised the bar for the executive power to block porn websites, full stop. The government can still block such websites, but only if they constitute a public order problem and unlikely probability. Savita Bhabhi, for instance, can hardly start a riot. Now, this brings us to study what were the original powers under the Information Technology Act and whether there were any blocking of websites prior to the insertion of Section 69A, as Mr. Manoj Mehta does talk about through the amendment in 2008, which was notified and brought into effect on October 27, 2009. And here, I would like to refer, in fact, to an executive order which does acknowledge it. So, blocking, whether it tantamounts to censorship and whether it has been done in the past, has indeed been done in the past without any underlying legislative power under the Information Technology Act by purely exercise of executive notification powers. For instance, a ministerial order on website blocking is dated 7th of July 2003, which notes, as already noted, there is no explicit provision in the IT Act 2000 for blocking of websites, full stop. In fact, blocking is taken to amount to censorship after listing cases where freedom of speech may not extend. Websites may not claim constitutional right of free speech. Blocking of such websites may be equated to a balanced flow of information and not censorship. So a curious position is taken where websites by themselves, when they are blocked, do not constitute a form of information, thereby not restricting a constitutional right by itself. This is very hard to imagine, given our conventional understanding, which is much more contemporarily developed. Now, let's look at Section 69 by itself, which was inserted through the amendment. It states power to issue directions for blocking for public access of any information through any computer resource. So in its short title, it does say public access, and then states in subclause 1 where the central government or any of its officers specially authorized by it or on its behalf are satisfied, necessary or expedient to do so in the interest of sovereignty, integrity of India, defense of India, security of state, friendly relations with foreign states or public order, or for preventing incitement to the commission of any cognizable offense relating to the above. It may subject the provisions of subsection 2 for reasons to be recorded in writing by order, direct any agency or government or intermediary to block for access by the public any information, to block for access by the public any information. I'm reading that again because there's an access right as much as there's a production, authorship, and distribution right which is impacted. So, by the public, any information generated, transmitted, received, or stored in any computer resource. It importantly states in subclause 2 the procedure and safeguards subject to which such blocking for access by the public may be carried out shall be such as may be prescribed. And this is prescribed subsequently in 2009 by what are called the blocking rules. The blocking rules merely follow a process in which a examining committee receives a request and thereby passes a direction with reasons recorded in writing for the blocking of websites. And it itself is somewhat problematic, in which two problems are noticed immediately. The first problem is that the notice which is sent prior to the website being blocked, providing for a hearing, which is a precondition of natural justice, which you lawyers may know, essentially that any person whose right is restricted will be given the opportunity to present a defense prior to an action taken to their prejudice. Such notice is not given to the person who's the author of the website. In fact, it mentions owner or intermediary. The owner itself of that website may not be the author. And secondly, especially in the cases of social media, secondly, the intermediary may just be the host or the platform. Thereby, the notice may not even reach the person who's authored the piece of content. So if you look at the terms of service agreements under which we publish information, even on blogging platforms, they make a assignment sometimes in which they uh, presume certain ownership rights by itself. Now, well, will those platforms provide that notice in a downstream manner or further forward it, thereby providing that notice to the person who's authored the content, thereby providing them the opportunity to actually present their defense before the government? And that becomes a very big question. The second is Rule 16, which states that there is a confidentiality bar with respect to any requests received by the examining committee and actions taken subsequent to that. So it would mean that not only the process from when it initiates and these requests are made, but even the legal orders which are passed subsequently to it would be secret. This provision, specifically the rules, have been challenged before the Supreme Court in the landmark judgment of Shreya Singhal versus Union of India, which in March 2015 upheld their constitutionality. This was disappointing because the court did not engage substantively with the arguments being made. And the arguments proceeded, firstly, on the lack of notice, secondly, with respect to the secrecy, thereby urging a constitutional right uh, that was restricted unreasonably, both with respect to the author and the second with respect to the public, which impacts its right to receive information and right to know. And this clearly springs from a understated reading of Section 69A, which does mention repeatedly the phrase public access. The particular paragraphs of the Shreya Singhal judgment, which in fact reason this, are from paragraph 109 to paragraph 111, which take into account these assertions but does not deal with it to a very high degree of appreciation, and summarily reason and then discount them. So, for instance, it states it will be noticed that section 69A, and I quote from paragraph 109 of the Shreya Singhal judgment, it will be noticed that section 69A, unlike section 66A, is a narrowly drawn provision with several safeguards. First and foremost, blocking can only be resorted to where the central government is satisfied that it is necessary so to do so. Secondly, such necessity is relatable only to some of the subjects set out in Article 19.2. These are the grounds which are provided under Section 69A, if you look at it. So they match the grounds under Article 19.2 except morality and decency. Thirdly, reasons have to be recorded in writing in such blocking order so that they may be assailed in a writ petition under Article 226 of the Constitution of India. Now we will see subsequently that because of Rule 16, which provides for secrecy, a person who's both an author or the public do not have the availability of any reasons in writing available with them. So when they do not have this order and they do not have the reasons, they cannot approach a court under Article 226, at least as per the ease and facility they should, if their right to access public information over the internet is indeed impacted. Now, going further and quoting from now, paragraph 110, the rules further provide for a hearing before the committee to be set up, which committee then looks into whether or not it is necessary to block such information. It is only when the committee finds that there is no such a necessity that a blocking order is made, full stop. It is also clear from an examination of Rule 8 that it is not merely the intermediary who may be heard, full stop. If the person in quotes, that is the originator, is identified, he is also to be heard before a blocking order is passed, full stop. Above all, it is only after these procedural safeguards are met that blocking orders are made, and in case there is a certified copy of a court order, only then such blocking can also be made. So the rules also provide for the originator essentially to be provided notice, but quite often they can't be identified, is what the court states. And it also states that court orders similarly can also be enforced through it. So there needs to be a lawful authority and a direction. So it's contrasting that with, let's say, private complaints, which can lead to blocking a website. So in its mind, it is being reasonable. It is saying that there will be good faith in the exercise of the power, and let's presume that. It is only an intermediary who finally fails to comply with the directions issued who is punishable under subsection 3 of section 69A. So the court seems more concerned with the criminal consequence of non-compliance of an order for direction of blocking of websites rather than the procedural safeguards which need to be there prior to restriction of the free flow of information on the internet. Now, continuing to quote further from paragraph 111, merely because certain additional safeguards, such as those found in sections 95 and 96 of the CRPC, are not available, does not make the rules constitutionally infirm. We are of the view the rules are constitutionally, we are of the view that the rules are not constitutionally infirm in any manner. End of quote. Now, what is section 95 and 96 of the CRPC? Those are powers which essentially draw their heritage from the older version of the Code of Criminal Procedure with respect to the banning of books, which link in turn to powers which are available to state governments to issue notifications in official gazettes, thereby to confiscate, prevent circulation, essentially ban books and pamphlets within the territorial extent of that state. And they relate to provisions of law under the Indian Penal Code, much more directly linked to hate speech offenses. So it's not firstly linked to the much more omnibus and generalized grounds in the Article 19.2. It's linked much more directly to the limited offenses for hate speech. Secondly, it requires notification or under the official gazette. And third, requires the state government to state grounds of opinion why those offenses are indeed constituted in its assessment within the gazette notification itself. Section 96 gives a special power of approaching a special bench of the High Court and for the High Court to also dispose of that matter expeditiously. Thereby, both in terms of the substantive power, there's an element of restriction in which it links to specific offenses of the Indian Penal Code, and also in terms of procedural guarantees, even though it may not consider a notice which may be given prior to a pamphlet, a book, or any written material being banned. It provides for a notification in the official gazette and an expedited remedy through statute before the state high court. Now, this has led to a large amount of precedent, if you search for it in legal databases, in which petitioners have indeed approached courts in high courts and have been successful in getting orders for prohibition of books set aside. In fact, my own personal experience when I worked on the case with respect to the banning of Mr. Jaswant Singh's book on Jinnah was such that we approached the court, the Supreme Court under Article 32, which was his own petition. However, a group of citizens approached the Gujarat High Court under Section 96 and, in fact, obtained remedy of setting aside of the government notification even prior to the final arguments in the Supreme Court itself, thereby demonstrating that the public's right to receive information was much more strongly upheld than the author's right to publish and to have restraints placed on their publication taken away, thereby showing the effectiveness of sections 95 and 96. The argument which is made quite often with respect to internet-based censorship is that the large body of information which is there would render such exercise of reasoned adjudication with respect to each individual piece of content to be incredibly tough and would then by lead to a large amount of materials which would not be able to be censored by itself. However, this argument has completely developed into a full banyan tree as we see it today, with the banning of complete platforms itself, and thereby also inverts the constitutional understanding where free expression is the rule, which is why legal safeguards as well as a legal basis is always provided to restrict the power of censorship and interference, thereby to keep it within reasonable bounds. This is also demonstrated in the case of dowry calculator, where it starts off with a tweet, as most things do these days, where Twitter as well as social network plays a social conversation on networks play a leading role in terms of governance in day-to-day life in India. Mr. Jyoti Raje Scindia, by his Twitter handle, quote tweets Amit Verma to state, and Amit Verma's original tweet is, uh, uh, it is not reinforcing harmful practices at the rate James India, it is mocking them. Plebeian is the poor soul who created that. Will he now relinquish satire forever for the fear that someone takes it seriously? This is with respect to the website Dowry Calculator. Quote tweeting him, Jyoti Rajesh India states, satire has its place, but not when it reinforces the beliefs. It mocks someone. Someone who goes to the site not knowing it's satire is bound to take it seriously. We must not make light of such harmful practices. In 2016, National Criminal Records Bureau reported 7,628 dowry deaths, full stop. Such satire is unacceptable. This is further tweeted towards Maneka Gandhi. Maneka Gandhi sends a complaint, who's at that point the Minister for Women and Child Welfare. And we found that through RTIs to the Ministry of Electronics and IT. And the Electronics and IT blocks the website itself. Now, I'm just sending a link to what happens subsequently in the interest of time, because I won't get into the details. But essentially, the creator, who's a film critic, Tanul Thakur, does not get notice despite being listed as the author in the registry of the website as per the WHOIS details. His email is listed. He gets no notice from the Ministry of IT. The IT ministry admits it. Secondly, the order itself in which the website is restricted is not made available to him, and it's still not filed before the High Court per se. So it's a secret order. And one can contrast the book banning power with the power to restrict and block websites, and transparency being a core issue, which is in fact preventing judicial remedy, judicial scrutiny, and access to justice. And this is why also blocking of websites, in fact, challenges the very framework of rule of law in India. Now, this has in fact been reformed to a certain extent by a judgment of accidentally, by a judgment of the Supreme Court this year in January, which is related to the telecommunication shutdown in Jammu and Kashmir, which took place shortly after the political reorganization and the revocation of its special status on August 5th of last year. And Essentially, in Anuradha Bhasin versus the Union of India, the Supreme Court holds that the right to access internet is linked to two fundamental rights: the right to freedom of speech and expression, and the right to trade and business, 19(1)(a) and 19(1)(g). And it states that the state's argument of privilege of not providing access to orders for telecommunication shutdown, which are made under the telecommunication under the powers of the Telegraph Act and the rules made thereunder, essentially cannot be exercised without the public being told what are the grounds under which the internet access is being prevented towards them. That same line of reasoning, which requires transparency, would arguably also require the publication of orders and would put a question as to the constitutional infirmity, at least of not the power, then the exercise of the power and the deficiency of the safeguards, which fetter information of orders which are made with respect to the blocking of websites under Section 69A. Hence, the challenge under Tanul Thakur is one I would urge the young lawyers here or law students here to follow with a great deal of interest, as it does represent a valuable opportunity for all of us to regain a greater sense of assessment at the very least, and access to information as to reasons why our right to receive information or to publish information is being impacted through state action. Now, let us come to the most recent example with respect to the blocking of platforms by itself by the union government, which was done this year. And there have been, I think, close to 4 orders or 3 orders, um, uh, including the one which was made originally. The orders have not been made public. However, a press release has followed each set of orders. So the first press release reads through the Ministry of Electronics and IT, and I'm pasting a link to it right now, and you can study it. And it states that government bans 59 mobile apps which are prejudicial to sovereignty and integrity of India, defense of India, security of state, and public order. Now, the first thing to notice is this is a press release, right? It's not a legal order which is issued under Section 69A or the rules, right? Secondly, what is also very apparent is that the reasoning which is given, which you see in the top part, which flows into, let's say, about 4.5 paragraphs, something like that, okay, has an appendix in which the 59 applications are listed. Now, if you look at the 59 applications, the first which is listed is TikTok, but the fourth which is listed is UC browser, and 9 is Hello, and 11 is UCam Makeup, and 12 is Me Community. Now, all of these are diverse applications with a diverse set of, firstly, owners, secondly, operators and users, third, with a different functionality set, and thereby different coding. What is the common element in it was speculated very widely in the press as being as to their origin being of China by itself. However, it is not spelled out clearly in either of the press releases which relates to these bans. Now, if we look at the statement a little much more closely, it states, and now I quote, the Ministry of Information Technology, invoking its power under Section 69A of the IT Act, read with the relevant provisions of the rules, in view of the emergent nature of threats, has decided to block 59 apps. Since in view of information available, they are engaged in activities which are prejudicial to sovereignty and integrity of India, defense of India, security of state, and public order. It goes on to state that the Cybercrime Coordination Center, Ministry of Home Affairs, has also sent an exhaustive recommendation on blocking these malicious apps. The ministry has also received many representations raising concerns from citizens regarding security of data and risk to privacy relating to operation of certain apps. The CRET-IN, which is the Computer Emergency Response Team, has also received representations from citizens regarding security of data and breach of privacy impacting upon public order issues. Likewise, there have been bipartisan concerns flagged by various public representatives, both outside and inside the Parliament of India. There has been a strong chorus in the public space to take strict action against apps that are harmful to India's sovereignty as well as the privacy of our users. On the basis of these and upon receiving recent credible inputs that such apps pose threat to sovereignty and integrity of India, the government of India has decided to disallow the usage of certain apps used both in mobile and non-mobile internet-enabled devices. The apps are listed in the appendix. This move will safeguard the interests of crores of Indian mobile and internet users. The decision is a targeted move to ensure safety, sovereignty of Indian cyberspace. Now, if you look at this, even if you take this press release to be a well-reasoned order, what are the deficiencies? Firstly, there's no specific factual finding. It restates to a large degree what have been public representations, however, does not go towards stating that whether they find the representations to be credible, whether this evidence itself leads to an inference with respect to findings which are then evidenced through the functionality of these applications. Thereby, it presupposes that just representations by itself, assertions by themselves, which are unstudied, can lead to determinations without a process of evidence and evaluation, which is worrying. And also, the orders with respect to them are not made public. Now, proceeding to the last element of why this should worry us as a rule of law society, as a democracy, is contained in a secret document which is called document number 9. And this is, in fact, an internal communique of the CCP, which is the party which exercises stranglehold on all aspects of Chinese life, being an authoritarian and a totalitarian society in many senses. And it states in document number 9 that it has a value which it has challenges, and then it also has problems. And this communique within the CCP was actually designed towards what it saw was a larger threat to the Chinese way of life, the culture of the Chinese state, and its distinct value, which stands in contrast to Western liberal democracies. So it essentially says that the internet is a core challenge. And in value number 7, it says that information networking poses a challenge to the control of our ideology. And it goes on to state that how this should be countered through greater centralization, state control, through undermining civil society actions, by centralization of power, and by monitoring surveillance of the online ecosystem. All of those values, which in fact would undermine through the use of technology a democratic basis of a free and open society. And this communique came to public knowledge in April of 2015, when the Wall Street Journal's reporter, 71-year-old Chinese journalist, was actually they published it and was subsequently convicted for releasing document number 9, and the and that was 7 years in prison for leaking state secrets to the foreign media. So this was published in 2015, and subsequently the person who provided and was the source was convicted. I think a similar situation right now pervades with respect to the secrecy around banning of websites in India, and especially to executive actions. Court orders, though, are disclosed through RTS, but proactively not published. Secondly, there is a high degree of populism which flows into the exercise of the banning power, which sometimes is applied without basis in the underlying textuality and the powers of Section 69A. and also the existing legal framework for the exercise of this power and the safeguards within them are not accounting for the fundamental right of an author to publish, and then in cases of censorship to avail remedies which follow principles of natural justice, and neither the remedies for the public with respect to its right to receive information. At the very least, what is required is free and open debate, because we are still a democracy. With this, I would like to end this lecture. It's been a pleasure addressing all of you here, and I hope this was valuable towards your time. I remain open for greater questions and answers around these issues, given that the issue of website blocking is a much more larger issue. I also remain open on any specific questions you would have on digital rights or on the Internet Freedom Foundation as well. Thank you.
Thank you so much, sir. Now we will move on to the Q&A session. One of the questions that have been asked is that was banning the app the only recourse that was available to the government? So even if we take the argument of the government that there was some privacy concerns, etc., would the government have not used the IT rules, the Section 43 rules to regulate these apps, even if we take the argument of the government?
So, as many people here know, India does not have a data protection law at present, and this does put a large amount of stress on any kind of enforcement with respect to informational privacy. However, there are recourses which do emerge, which do are available under Section 43A. I don't think so. They have been exercised in this manner before, in terms of directions which may be given to intermediaries to safeguard user information. However, I do believe that if there were emergent threats, even legislative powers or ordinance making powers could have been taken recourse to, because the present actions do not have any basis under law, at least in terms of blocking by itself. So if you look at it, blocking is essentially a remedy, it's a punishment. It's not essentially a finding which then presupposes a remedy. So at the very least, if you look at even the draft data protection bill, the remedies which are following the provisions within them also contemplate for remedial actions, given that internet and smartphone applications, especially these 59, do provide value to users all over India. And even if they are providing value, they may be doing it in a way which is harmful. However, those harms need to be individually categorized. They need to be identified through evidence, and then remedies need to be imposed in terms of structuring. And if there's a larger risk, a much more reasoned argument needs to be made, rather than sudden, unexpected actions such as this, which give a large degree of uncertainty with respect to the digital ecosystem in India and puts a question mark on our rule of law.
Thank you, sir. Another question which was posed was that the USA also tried to ban TikTok recently, and I think that the case went to the courts also. In the Washington D.C. District Court recently gave an order saying that they cannot ban TikTok. So, what parallels or contrast do you see with the Indian situation?
I think I've not studied, quite frankly, Harshit, I've not studied it in great detail, and I'm not confident providing that answer. I hope the lawyers who are trained both in Indian as well as American law will be able to comment on it. All I can say is that there has been no court challenge in India itself to the ban of these applications. That's the first thing. And the second thing I think I followed was that uh, rather than TikTok, it was creators who are called influencers, who derive some revenue from presence on these social networks. They approached, I think so, the New York court. So here I think it's somewhat telling that people did not approach the court itself in terms of either them being creators or them being the owners of these applications themselves.
Right, sir. Uh, One of the other questions was that what impact do you see of this ban? As in, do you see that the apps will be reluctant to enter into the digital space of India because of such whimsical bans, or do you see that the market has not been impacted much? In practice, what impact do you see?
I think as a lawyer, what does worry me are arguments which are made much more towards my understanding of being a slippery slope. So once you undermine the rule of law in A instance, it spreads to B instance and C instance, and then becomes a continuing practice in terms of precedent. And we've seen already four sets of bans. And traditionally, the banning power has been contested and has been applied in the marked domain of obscenity, sexuality, morality. And the second domain where I've seen much more active enforcement, though emerged from court orders, has been intellectual property. Now, a new domain has been opened with respect to the national security doctrine, and which is very boundless. It's not defined, and sometimes asking for an objective basis of determination, principles of natural justice to be followed, uh, high degrees of transparency, almost seems to be a, a request rather than a firm assertion. And this request also is then often met with a question as to patriotism or nationalism with respect to the person who poses these questions. So I think it's growth in government power, number one. Number two, I think it leads to a variation from the rule of law. It's such a very worrying precedent, and I think it brings a level of uncertainty, given that if you look at that it's been championed by a lot of local startups for creating what could be a market opportunity for them due to the vacuum caused by the blocking of these applications. So it sets a very, very worrying precedent. I think in attempt to block these applications, and this is a much more political comment, and I hope the viewers discount this, but I think in hopes of blocking what China has done, we've in fact revealed a sense of national insecurity, almost bordering on an envy of the authoritarianism in China, departing from our democratic traditions.
Right, sir. One last question that was posed is something unrelated, but it's very important. So it says that the government recently banned internet in Jammu Kashmir, then Delhi, then Assam also. So do you see the parallels with the government action in which the procedural safeguards are often discounted and the fundamental right to freedom of speech and expression is, taken very casually?
So there's a large amount of scholarship which has several strands of thought around freedom of speech and expression, and several people have written on it, and they bring into focus and put a large amount of introspection as to both the action by the legislatures and the executives, and second by the courts with respect to how often they have actually uh, enforced the fundamental rights to freedom of speech and expression as opposed to the restriction on those rights. They seem to, in fact, place a large a question mark with respect to whether these rights have truly been respected by itself, or have these spaces been negotiated to a degree where it's only been allocated towards people in positions of power, privilege, or in terms of balancing in terms of perception of the availability of freedom of speech and expression. I think when we look at the internet, it's only become the way to understand it is that even though the internet provides a high degree of facility technically, which is and economically, which has never been there for people to reach large numbers of people seamlessly, instantly, through very less friction at marginal cost compared to analog modes without licensing. However, at the same point in time, the fetters on them and the centralization of power towards this flow of information is gradually developing both through technical and legal controls. And the centralization of power essentially will then vary towards how powerful the center of the state is, and in terms of how desirous it is of controlling a public discourse. So it is worrying. There are parallels. However, there has been no neat period in India where we've had incredible amounts of freedom of speech and enforcement around it, to when we do not have any. I think it's always been a negotiated space. Now, with respect to internet shutdowns, though, if you want to understand more around it, have things become worse? Yes, as per studies which are put out by the Freedom House Index, as well as the global count with respect to internet shutdowns, India has been faring poorly, and its record is only becoming worse on a year-to-year basis. This is because in Jammu and Kashmir, the internet shutdown is exceeding or touching close to 500 days. In Rajasthan, West Bengal, Delhi, as well as several other states, internet shutdowns are being done on a regular basis. The right to information requests which we have filed through IFF have shown a low amount of deference to the Supreme Court's judgment in Anuradha Bhasin with respect to proactive publication. Again, transparency is lacking. In fact, Andhra Pradesh wants to maintain the power under Section 144 of the CRPC to issue internet shutdowns, which has been quite clearly been stated not to be a power to be used to shut down the internet by the Supreme Court, which should only be done under the Telegraph Act as per the Supreme Court under Anuradha Bhasin. So I do see very, very clear, visible fault lines, and it brings an incredible amount of worry, but also provides an incredible amount of motivation to me and my colleagues and the Internet Freedom Foundation, because we do believe that the internet is a force of which can promote democracy, which brings an immediate availability of freedom of speech and expression through a technical facility. More people need to have it, and more people need to have it with the political, civil freedoms, which allow them to be full participants in a digital democracy.
Thank you so much, sir. Sir, we have come to the conclusion of today's webinar. I am Shubh, and I am a member of LTech at National Law School of India University, Bengaluru. On behalf of the entire law school, the Law and Technology Society, as well as all the participants, I would express my hearty gratitude to Mr. Apar Gupta for sharing his deeply insightful words with us in today's webinar. We cannot thank you enough for taking off your time of your busy schedule to give us such an interesting and interactive experience. And I'm sure each one of us will be taking away some pearls of wisdom. I would thank you for giving us the time for incorporating the interesting questions asked by the viewers. I would like to thank the IT department and SCC for being the media partner and publicizing this event. And also would like to thank all the participants for joining the webinar and making it a great success. We are sorry if we couldn't take your questions.
If I may say something,
Yes,
Shubh,
sir, sure.
thank you so much. And I'll just add one more line. Thank you for all of your time on Saturday. I really do appreciate it. You could be watching Netflix or doing things or reading a book, which would be much more valuable than this interaction. But if you do have questions, you are passionate about technology, digital rights, what's emerging in this domain, we are a community-centric organization at IFF. Me and my colleagues are always happy to engage with all of you. Please do register on the forum. Please do interact with not only with me, but a lot of technologists, people who are working as engineers in different startups building these technologies. And let's engage in sustained conversation, because I think through a better understanding of what's happening in the technology sector, we can really make sure that our fundamental rights are well protected and cemented for the future.
Sure, sir. And so to add to that, considering the mass participation and interest shown, I have no doubt that our society and the college will coordinate to continue this great endeavor and host an integrated series with renowned speakers and exciting topics. In the similar vein, we are organizing another webinar next week, so stay tuned for the notification for the same. At last, I request everyone to fill the feedback form. The link for the same has been sent in the chat, and the certificates of attendance will be sent once you fill the form. Once again, I thank you all.
Thank you so much, sir. Thank you, everyone.